Hey everyone, my name is Adam Tomasi. I am a Champion Briefs brief writer, and this is the March-April 2023 LD topic analysis for the resolution, which is currently resolved. The justices of the Supreme Court of the United States ought to be term limited. This topic analysis is going to cover the essential themes and excellent strategies that you could take advantage of and use to win lots of debates on the March-April resolution. And I also encourage you to check out the Champion Briefs and subscribe to those now because you'll be able to get a hold of hundreds of cards, which will help you write fantastic cases on both sides of the resolution. So let's dive right into this topic. The resolution is about the Supreme Court. The Supreme Court is one of the three branches of the federal government of the United States. And the Supreme Court derives its power from Article 3 of the Constitution. Article 3 in the vesting clause establishes, and I quote, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Just to note, inferior in this context does not mean of lesser value. It means at a lower level on the judicial hierarchy. So you have the lower courts, like the district courts, the circuit courts, and the Supreme Court is the supreme, as in it is the highest court of the land, which is meant to render the final word on important constitutional questions and matters of how to interpret the law. But to continue with the vesting clause, quote, "The judges, both of the supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office." So the vesting clause does not explicitly establish that Supreme Court justices have lifetime appointments, which is the policy and norm under which Supreme Court justices are nominated and then confirmed. That if you become a Supreme Court justice, you have that position for life until you retire, you are impeached, or you die. And the way that lifetime appointment is connected to the Constitution is that the phrase "shall hold their offices during good behavior" is interpreted to mean that so long as the justices do their jobs in a satisfactory way and aren't, corrupt, aren't breaking the laws themselves, doing, things that would constitute impeachable offenses, then they have the position as long as they live or as long as they choose to serve it, compared to the other articles of the Constitution, Article 1, which establishes Congress, and Article 2, which establishes the presidency, as each of those Articles 1 and 2 specify term lengths for representatives, senators, and the president of the United States. Whereas Article 3, when it was constructed by the framers of the Constitution, did not say Supreme Court justices will only serve X amount of years, X amount of terms. It said, so long as they maintain good behavior, they will have this position. So that's been interpreted to mean lifetime appointment. The way that advocates of term limits for Supreme Court justices get around this constitutional question, because it seems like the Constitution makes a closed case, is they either propose a constitutional amendment. So as the affirmative, you might say that your advocacy is that the country come together to approve a constitutional amendment that would revise the vesting clause and establish that justices would not stay in the position indefinitely, maintaining good behavior. Or you could argue that a term limit system that promotes Supreme Court justices that are made to retire into senior justices, such that they will, hold the position of like a senior status where they would serve on lower courts and even be called upon to fill Supreme Court vacancies. If a Supreme Court justice suddenly passes away, no one expected it, that a former Supreme Court justice who holds that senior title would then assume the position as an interim justice until a new one is confirmed. That is a system that could also be implemented by the affirmative with term limits, such that even if you boot a justice off the Supreme Court after they serve a term of, say, 18 years, which is the common proposal for term limits in the literature of one non-renewable 18-year term for Supreme Court justices, that even if your 18-year term is up, you still are part of the system and serve in the lower courts, the inferior courts, as the Constitution says. So that would be a way that one would be able to hold their office during good behavior, because the nature of the office would just change within the federal judiciary, which you still get to be a part of. So that's a more creative way that term limits advocates will say that they're not violating this precept of the Constitution. But apart from the legalese there, it's also important to think about how term limits for Supreme Court justices would actually get implemented. Because when you have these debates on either side, you definitely want to get down to earth and think like, okay, if we had term limits for SCOTUS justices, how would that actually take place? How could that actually be made concrete and actually done? And term limits advocates, particularly this one group called Fix the Court, proposes that term limits would not be applied to current Supreme Court justices. So all 9 Supreme Court justices presently serving who were confirmed with the guarantee of a lifetime appointment would get to serve the remainder of their term for life. So term limits would not mean that we would be going to the justices that the 3 justices that Trump confirmed, for instance, Gorsuch, Kavanaugh, and Barrett, or going to someone like Chief Justice John Roberts, who's been on the Supreme Court for a long time, and just telling them, your time is up. We have term limits. So now all 9 justices that are currently serving in their positions have to leave, and we have a completely new slate. That would not be what takes place with term limits. The way that term limits for SCOTUS justices are typically constructed would be that the term limit would go into effect the moment that a new Supreme Court justice is to be confirmed. And that would progress to the point where eventually all 9 Supreme Court justices would eventually end up being on those 18-year terms. And just to explain like the math on that, Fix the Court actually has a great schematic of how term limits would work in practice. So they say, and I'll read some of the text here, let's assume that the current justices are exempt from any new term limits law, and that they, like Sandra Day O'Connor, former Supreme Court justice, will serve until age 75. Given the health issues of half the current court, we believe that's fair. So the retirement age for each of these justices could be totally variable. Some could serve until they're 89, 90 years old. Some might pass away a lot sooner. Some might leave the position at the age of 60. We can't really know for sure, especially because a lot of the justices that have been recently confirmed are relatively young, but by Supreme Court standards. But nonetheless, Fix the Court is saying that it's a fair working assumption that all of the 9 justices currently serving would retire at roughly, 75, meaning that they will have all served more than 20 years. And then they say, let's also assume there are no retirements in presidential election years. And then beginning the calculations from 2020, they imagine that a term limits law passed in 2021. We're obviously past that. They imagine one person retires, a new term limited justice is confirmed, and then you have 9 justices. Then this term limit system would be one where every 2 years, a new Supreme Court justice is confirmed for a non-renewable 18-year term. So if you establish that system of regularizing the process, so every 2 years, a new justice is confirmed, that would mean that some years you have more than 9 justices. which is also quite unconventional because for much of the country's history, we've had 9 justices. That wasn't the case at the time of the founding, but it's what we have now, and that's remained constant and is expected to hold in the status quo. I mean, there are talks of court packing, of expanding the number of justices that serve on the court in order to combat the immense political bias that exists on the court today. But term limits would be a different solution that also, in a way, adds to that number of 9 justices. So Fix the Court estimates that in some years, you could have 10 justices. In some years, you could have 11 or 12. And that's just because of the math of taking the 9 justices that currently exist and then calculating when each of them is likely to retire, plus the new term limited justices that are being pumped out every 2 years after the term limits law is being created, and the expectation that they serve their full 18-year terms. And then, I know this is long-winded, Fix the Court concludes that by 2047, which is when they expect Amy Coney Barrett to retire, that all 9 justices would become permanent. The 9 justice system would become permanent, as all 9 justices would be term limited by that point. Of course, this schematic was not written at the time that President Joe Biden confirmed Justice Ketanji Brown Jackson. So term limits might be fully implemented even later than 2047, because after Barrett retires, then we assume that Ketanji Brown Jackson would still be serving the full duration of an average Supreme Court term. So that would be a period where we would potentially still have 10 justices or 11 justices. And then by the 2050s, we would have 9 justices who have all been confirmed under the single 18-year term, and no longer any remnant of a justice having been confirmed for life. So that process can be very lengthy and long-winded to think about. But the point is that if the implementation appears difficult and protracted, that this should not be a hindrance to affirmatives that want to make like a strong argument about the present day, where you may not be able to argue that we could have term limits tomorrow and then be able to restore abortion rights this year. For instance, if we're thinking about the overturning of Roe versus Wade as a moment of the Supreme Court's legitimacy crisis. So a lot of advocates for term limits have been responding to that moment and the cratering public trust in the Supreme Court as a result of that decision and other recent ones made by this very conservative-leaning Supreme Court. So you may not be able to prove that term limits would change anything this year or this decade, though you could argue that as the system gets rolled out, you will see some incremental but significant shifts in the way the court operates, especially if you start to see Supreme Court justices who are term limited joining the ranks of the current court. So with that schematic from Fix the Court, thinking about the interim period where you have 10 justices, 11 justices, and 2 of those justices are term limited, and they might serve as a check. They might serve as a positive influence on the existing Supreme Court. The affirmative could even argue that with term limits, there would be greater encouragement of current Supreme Court justices to retire and pave the way for a new generation of justices to take their place. So you don't want to take the outline that I described earlier from Fix the Court as the only prognostication of how term limits for the Supreme Court could develop, because there will certainly be authors that say that a term limits law could really get the ball moving sooner. But you just want to think about those details of implementation when looking at the topic. Now, as we've gone over the nuts and bolts of term limits a little bit, thinking about that core proposal of a single non-renewable 18-year term for SCOTUS justices, which, by the way, that number 18 is in reference to the hope that having one justice confirmed every other year, where you have the hope that with the presidential term schedule that every president would be able to then confirm at least one or two justices. That's the way the math shakes out, that the purpose of the 18-year number is then to equalize and regularize the process, so that rather than having a stacked deck of President Obama only he nominated two justices over the course of two terms, whereas Trump was able to nominate three justices in one term, where that's pretty lopsided historically. And with term limits setting up, every odd year, a new justice has to get confirmed. This would mean that every president would have a fair shot at changing the makeup of the Supreme Court, because it's also possible that you could have a president that never gets to nominate anybody with the lifetime appointment system. So just wanted to clarify that as well. If you're thinking, why 18? Why is that a significant number for the term? But now that we've again clarified the nuts and bolts, we can look at some core themes of the topic literature. And there are two that are very interrelated about legal innovation and legal stability. So I'll start with legal stability. One of the criticisms of term limits for SCOTUS justices is that by constantly changing the composition of the court, like who serves on it, this would lead to more drastic changes in how statutes, like laws, and how the Constitution is interpreted. Because if you have a group of 9 people that have lifetime appointments and they're all there for a very long time, you're going to have a lot more constancy in how they rule, because these are the same people that are steering the ship in the same tight direction. Whereas if you have more turnover, you're going to have a lot more like different, potentially drastically changing perspectives. And this could lead to a lot of irregularities in precedent and how the law is interpreted. And that might not be setting a good standard for the Supreme Court, which is supposed to interpret the law in a stable, neutral way. Now, the flip side of that is legal innovation. So advocates of term limits make a strong argument that we need to incorporate fresh perspectives, fresh blood into the Supreme Court to ensure that Supreme Court justices as a whole are not so insulated from everyday life and from new and recent trends in legal analysis. So if you have people that are serving on the Supreme Court until they're well into their 80s or 90s, there's no guarantee that they're trying to keep up with the times, not just as a generational thing, but also in terms of legal doctrines. So are the older Supreme Court justices stuck in a time warp where the way they think about the Constitution belongs to the 1970s or 1980s? That those decades called, and they want their SCOTUS justices back, right? Maybe a newer crop of Supreme Court justices that are much younger and are being nominated and confirmed more regularly would be more in tune with the way that the legal profession and that constitutional scholars recently understand certain important and significant issues. And then also with that higher turnover, we get the greater possibility of diversifying the court, whether that's along racial lines, gender lines, but also generational lines, ideological lines, right? If every presidential term has an equal fair shot at influencing the makeup of the Supreme Court, that this is going to make the institution more vibrant and adaptable and less stale and insular and illegitimate in the eyes of the public. So it's more responsive then as well to what the public looks for in a democratic institution, just as Congress constantly changes. The turnover of a House representative having to run every 2 years is certainly not something that we would necessarily aspire for with the Supreme Court, as authors would agree. But the principle there of higher turnover can be seen in the same logic that we hold with why we don't have presidents for life and why we don't have representatives and senators for life. Now, another reason why we might differentiate between the Supreme Court and those other institutions is that we might care more about increased turnover for positions that should be elected. Whereas the negative could say that the Supreme Court is meant to stand outside of that constant democratic turnover. That's why Supreme Court justices are not directly elected, and they need to be a more steady hand against constantly changing, public attitudes in order to preserve certain fundamentals of the Constitution and of certain essential rights, and so on. So the negative could say that the Supreme Court then is a bulwark against the tyranny of the majority, whereas the AF would argue that the Supreme Court needs to be a more vibrant and functioning institution that receives these different inputs from the largest possible cross-section of society, such that the Supreme Court, even as it serves this unique role as not being a conventional, direct, or representative democratic institution, that it still needs to stay fresh and it still needs to have a more democratic energy being constantly, injected into the process, which term limits may be able to accomplish. So you have the legal innovation component, you have the legal stability component, and that's also going to get into debates about the value of precedent. So there's another important doctrine to think about with this debate between stability and innovation, which is called stare decisis. So stare decisis is a Latin phrase which is associated with the judicial philosophy that judges and justices should generally respect the precedents that their court has previously established. So if you're a Supreme Court justice, your job is not to go in there in a barnstorming mission to overrule all the decisions that were made by your predecessors and completely turn the court over a new leaf. Instead, the goal is to generally be respectful of the rulings that were made by the previous Supreme Courts, but tweaking them as needed in light of new situations, in light of a changing society, while still generally respecting that those rulings have the force of law and should constrain the decisions that justices make, so that they're not shooting from the hip and making totally unrestrained, supported decisions in terms of the buildup of law over time, that inherited wisdom, institutional knowledge, right? But stare decisis does allow for the overturning of precedent when those previous decisions have been found factually incorrect, enormously misguided, just totally wrong about what the Constitution says. So on the one hand, we have Brown versus Board of Education in 1954, which overruled Plessy versus Ferguson, the Supreme Court precedent from the 1890s, which had established separate but equal, aka racial segregation in all public facilities, and that had built up the Jim Crow South. And Brown versus Board of Education had overruled that precedent, where the Supreme Court had, by the 1950s, established that racial segregation is not supported by the Constitution, and in fact violates the Constitution, particularly the Equal Protection Clause of the 14th Amendment. So rather than the Supreme Court saying that the previous 19th century Supreme Court and its support of racial segregation has to be respected, a future Supreme Court said that that is bonkers and totally against what the Constitution is really about. But the same mindset has also been applied to the recent overturning of Roe versus Wade. The 1973 Supreme Court decision that had established a constitutional right to an abortion, in the United States. And, this law has been so important, for the expansion of reproductive freedom in the United States, though it has also been very contentious to the pro-life movement and to many states that have restricted abortion through all sorts of different ways that attempted to be consistent with Roe v. Wade in some respects, because the decision did allow for certain restrictions, but in other respects were intended to deliberately contest Roe v. Wade. And that finally came to a head with the new conservative majority on the Supreme Court, which throughout the previous mindset held even by right-leaning SCOTUS justices that Roe v. Wade is precedent and therefore it has to be respected, even if the justice is personally pro-life. Whereas the new conservative majority decided to throw that out on the basis that from their perspective, Roe v. Wade was an incorrect judgment of constitutional rights. So that also demonstrates the risks of, from many people's perspectives, of upending precedent. So it becomes a double-edged sword of overruling precedent when we would all collectively say that that precedent was wrong, such as Plessy versus Ferguson, separate but equal, whereas the overturning of Roe v. Wade on the justice's basis that they disagree with it. Now, others might say that there should have been more respect for precedent. So it can be a difficult line to draw, but it is one that interacts very much with the question of term limits, where if we have this increased turnover on the Supreme Court, how is that going to affect precedent? And if it does affect precedent, is that for better or worse for the country? And how does that also impact Supreme Court legitimacy, which depends upon public perception of the rulings of the Supreme Court and how the Supreme Court makes those decisions? And you can also imagine legitimacy crises that may pop up for the Supreme Court while you are debating this topic. So the Supreme Court is reviewing a case now about the legality of President Biden's executive action to cancel a large portion of student debt for many Americans. And the conservative-leaning Supreme Court is presently skeptical of the arguments made by the president for the legality of unilaterally canceling any student debt. So it is very possible that as the Supreme Court, establishes a ruling that the president can't do that, that there would be so many student borrowers who get thrown into this financial limbo as a result of the decision. And already they're in a legal limbo of, is this debt going to be canceled or not? So that outcome of striking down the student debt cancellation might also threaten the legitimacy of the court. So that's something to be seen as well in the coming months. Now, in terms of thinking about other dimensions of the topic, as we wrap up the topic analysis here, you want to think about how there are effective utilitarian debates to be had, and there are also really sophisticated philosophical non-utilitarian debates to be had as well. So the utilitarian debates on the topic would be largely about the material consequences of having an illegitimate Supreme Court, having a weakened democracy, the way that the United States failing to send a signal to the rest of the world that it is a functioning, successful democracy may spur a shift worldwide towards less democracy. It may embolden authoritarian great powers to expand their influence because the United States would increasingly lose its credibility as a democratic power in the world if it can't get its own house in order, particularly with an institution as important as the Supreme Court. So you could draw massive consequences from that. You could talk about the effect that term limits might have on very specific issues, such as abortion or campaign finance or free speech, student debt, and so on. And you could talk about the material consequences of those. And finally, you could also argue from the impacts that a functioning rule of law may have on curbing violence, because you might argue that an illegitimate Supreme Court would denigrate respect for the rule of law, and that might lead to a greater increase in civil violence, conflict, and so on, which would be detrimental to the internal stability of a democracy and also lead to loss of life. From the AF perspective as well, in terms of philosophical debates, you could write frameworks that are about democratic legitimacy. You could start from the principle that democracy is really something we want to prioritize and preserve, but argue for that from the perspective of equality and representation and agency versus looking at the material consequences, like with util. You could write cases on both sides about democratic legitimacy. You could also appeal to virtue ethics. So in the brief, we have some discussion, particularly in my framework, topic analysis, shameless plug, about how you can use virtue ethics on the term limits topic to discuss the obligations that justices have to make decisions virtuously and to be free from corrupt influences. And there is a fascinating literature about the extent to which term limits would lead to more or less corruption, whether term limits would reduce corruption by increasing turnover, or whether term limits might increase corruption because the Supreme Court would become more responsive to political pressures and shifting political winds. And consequently, you could impact out corruption from a virtue ethics perspective. So using the virtue ethics framework to supply your impact. For why is corruption bad? Well, because it is an affront to judicial virtue. So judges and justices must practice virtue, and corruption would go against that. So that's another route that you can pursue. Finally, I'll note that apart from the framework debate, apart from the util debate, you could also consider the counterplan debate. So there are plenty of fascinating counterplans like court packing, even age limits instead of term limits. So, for instance, the Supreme Court of India, but also other parts of the world, they have a mandatory retirement age for their Supreme Court. And that mandatory retirement age in India is 65. So that's different from term limits because instead of having a single non-renewable 18-year term, regardless of how old you are, you could be 72 and you could be confirmed to one 18-year term. Having a mandatory retirement age would maybe incentivize nominating younger justices, but it's also just different from term limits in the way that they're proposed by the affirmative. So that could be an interesting debate between two competitive options. And then another source of competitive negative advocacies would be in the world of critiques. You could, as the negative, argue that the Supreme Court is an inherently illegitimate institution that should never try to be saved, and that the affirmative attempting to restore Supreme Court legitimacy is a counterproductive and oppressive project. So you could say abolish the Supreme Court. You could implicate the Supreme Court in capitalism, anti-Blackness, patriarchy, and so on, and say that the institution cannot be redeemed, and that the AF is a project of liberal capitalist democracy, which bakes in inequality and domination. So there are fascinating historical and contemporary analyses of how the Supreme Court is designed by its very existence to maintain those unequal and oppressive systems. So that could be another route that the negative pursues. And if you're the affirmative, you will absolutely want to think about what your angle is against those positions. So how might term limits improving the Supreme Court do so in ways that makes it easier for grassroots radical movements to successfully shape the direction of the Supreme Court and ultimately lead to more socially just outcomes? To do that, the affirmative will have to deal with the hollow hope thesis, which is the argument that social movements putting their faith in Supreme Court decisions and in judicial decisions more broadly actually knocks the wind out of the sails of those social movements and makes them less impactful and effective in the long run. So the affirmative will certainly have to, dig deep into the literature to argue that the Supreme Court is still a worthwhile institution and that it can be retooled and radically shaped towards more fair and socially just and equal outcomes in our society, which term limits might be the first step towards doing. So there are lots of, excellent considerations, on this topic for both sides, especially because, and I like this with March, April topics, there's so much literature that just makes the straightforward proposition for or against term limits. So you will not struggle to find dozens, if not hundreds of articles that stake a clear, well-impacted position for or against term limits. So with that, I hope you have some fantastic debates on this topic. I think you can tell from my enthusiasm that it's a very interesting and engaging topic to debate. Again, my name is Adam Tomasi. I am one of the Champion Briefs brief writers, and I encourage you to check out the Champion Briefs for this topic, where we have hundreds of cards and how-to guides for cases, as well as topic analyses to help set you on the right path for some strategies that are going to win you tons of debates. So thank you, everybody, for watching.